All right, my friends, Jared Dukes here. I am your free-minded educator, and I have a great story for us to go over today. Without further ado, let's get right into it.
Okay.
Ready, Miss Smith? Oh, okay. Let's go on the record with 23 SC 188947, State versus Kenneth Chesebro. We had begun our jury selection process this morning, but I've been informed that there is a change of plea. Is that correct, Mr. Wade?
That's correct, Judge.
Is that correct, Mr. Grubman?
Yes, Your Honor.
All right. Was this negotiated?
It is, Judge.
All right. In that case,
All right, just quick background here. As you may have guessed, this has to do with what I call the real fraud case against Donald Trump. The fraud is on Donald Trump, a little bit of a play on words here. But essentially what's going on is, as you may or may not be aware, in the state of Georgia, the democratically elected Fulton County District Attorney, Fannie Willis, I believe is her name, she has brought a RICO charge, which essentially is racketeering, internally corrupt organizations against our dearly beloved former president, President Donald Trump. She has indicted him, in layman's terms, basically having to do with the last election in 2020, where Donald Trump and his attorneys and other allies basically fought to have the election overturned. Never in American history has this ever happened. This is such a ridiculous thing that's going on. It is just extremely upsetting, but we can all learn a lot of lessons from what's happening to our dear president, President Trump. So right now you're watching this video from the end of last week, Friday, and this is a feed directly from the courthouse in Fulton County in Atlanta, Georgia. You have the judge who is now hearing a motion. They have entered a plea. Originally, they were going to go ahead and pick a jury for this Kenneth individual, this former attorney of Donald Trump's, and they were going to, his last name, by the way, is Chesebro. I believe I'm saying that right, Kenneth Chesebro. He was going to go ahead and not take a plea deal, and he was going to basically pick a jury. That's what they were in the process of doing. He went ahead, his attorneys went ahead and talked with the other side, and they have secured a plea deal. So let's get back to it and let's hear exactly what's involved with this plea deal.
whenever counsel are ready, and wherever's most convenient to Mr. Chesebro, you can stay seated, use that microphone or that microphone, but we could swear in Mr. Chesebro and proceed with the colloquy.
Do you want me at the podium, Judge?
Well, I think he's going to take the podium, so why don't we have you there?
Sorry. You stand right there.
Okay. Probably need you where we can hear you. Oh, did we really?
That's okay. I can stand. Can you hear me from here? Okay, cool.
Basically, they have to read all this into the record.
Judge, would you like me to give you the conditions of the sentence or the recommendation?
If
prior
it's
to
if
going
it's
through?
negotiated, I think we can just start at the
Go through
top.
it? Okay, got it. Thank you. Mr. Chesebro, can you please raise your right hand? Do you swear or affirm the testimony you're about to give should be the truth and the whole truth, so help you God?
Yes.
Please lower your hand and state your true and correct legal name.
Kenneth John Chesebro.
And are you the Kenneth John Chesebro named in the indictment 23 SC 188947?
Yes.
Are you under the influence of any drugs, alcohol, or medication today?
No.
Is there any medication that you should be taking that you have not taken today?
No.
How old are you and how far did you go in school, sir?
62, I went through law school.
Are you able to read, write, and understand the English language?
Yes.
Have you gone over the indictment with your attorney, Mr. Grubman, as well as Mr. Aurora?
Yes.
Do you understand that you were originally charged in count 1 with RICO, count 9, conspiracy to commit impersonating a public officer, count 11, conspiracy to commit forgery, count 13, conspiracy to commit false filings and writings, count 15, conspiracy to commit filing false documents, count 17, conspiracy to commit forgery, count 19, conspiracy to commit false statements and writings?
Yes.
Do you understand that the state that this is a negotiated plea, and as part of that agreement, the state has agreed to null pros counts 1, 9, 11, 13, 17, and 19, and will be moving forward on count 15 only?
Yes.
Has your attorney advised you of the minimum and maximum sentence for count 15
So far what we're learning is they basically, the way the prosecutors work is they take everything they possibly can and they throw it at a defendant, such as Mr. Chesebro. And because of this plea deal, they're going to go ahead and forget all the other counts, and they're just going to focus on him pleading guilty to one count, which will secure their ultimate goal.
which is conspiracy to commit filing false documents.
Yes.
And do you understand that that carries a minimum of 1 year to a maximum of 5 years to serve?
I do.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you reviewed the waiver of rights form with your attorney?
I have.
And have you signed it as well,
Yes, I have.
along with Mr. Aurora?
Yes.
Judge, if I may. Have you had enough time to speak with your attorney, Mr. Aurora, and Mr. Grubman?
Yes.
Have you had an opportunity to talk with them about all the facts and circumstances regarding the charges in the indictment, including your potential defenses?
I have.
Do you need more time to discuss your case with either of your attorneys?
No.
And are you satisfied with their services?
Yes.
Mr. Grubman, do you waive formal reading of the indictment?
Yes.
Do you waive any and all defects that may lie within that indictment?
They have to make sure that they get all of this on the record because they want to make sure that all their I's are dotted, all their T's are crossed, literally. They don't want to have this go up on appeal and it be overturned or something is done incorrectly and then this particular defendant has to be retried.
Yes.
Mr. Chesebro, have you been arrested on these charges that lies in indictment 23 SC 188947?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that involve these charges?
No.
No.
Do you understand that this is a negotiated plea, which means your attorneys and the state have reached a negotiated recommendation to make to the court?
I do.
Do you understand that the court is not bound by that recommendation and could sentence you to the maximum penalty for the charges?
I do.
Do you understand that the recommendation in this particular case as to count 15, conspiracy to commit filing false documents, is 5 years to be served on probation, a $5,000 fine, and that you are, I believe you're asking the court to treat you as a first offender, is that correct?
Yes.
I'm sorry, $5,000 restitution. You understand that?
Yes.
And do you understand also special conditions of the probation is that you complete 100 hours of community service? Okay, we have to take just a quick intermission here because I want to explain something to you. Okay, so what you need to know, you heard the reader, the court reporter, processor, whatever. She is reading all these statements, if you will, into the record so that everything is crystal clear as to what the agreement is in case it has to be revisited again in the future. You heard her talk about that it is agreed that you will be treated as a first offender. This is very important. Some states have these first offender laws because what Mr. Chesebro is pleading guilty to under number 15, count number 15, is a felony. It only has to do with handling records or mishandling records or whatever the specifics are. However, it's a very serious problem because it is a felony versus a misdemeanor. With Georgia's first offender status, if you successfully complete what you have agreed to, and all of this, of course, is going to be outlined right now, but if you complete it and you're successful and you don't have any other run-ins with the law, what is supposed to happen is your record is wiped clean. It's as if you never had it happen at all. You remember the ServPro commercials. You probably have heard the ServPro commercials where basically they say like it never even happened. That's exactly what's going on here is the ServPro mentality in this particular one. But at any rate, let's get right back into it.
Yes.
And that you write an apology letter to the citizens of the state of Georgia?
Which I have, yes.
Yes. And that you truthfully testify at all hearings and trials involving co-defendants in this matter, that you have no communication with co-defendants, witnesses, or the media until all cases have been resolved against all co-defendants.
Yes.
And do you understand that you must give a full recorded proffer with the state, that you continue to also provide documents and evidence subject to any lawful privileges asserted in good faith?
Yes.
And Your Honor, the defendant has already done an apology letter, which the state will tender into evidence in State's Exhibit Number 1. And also this morning, Mr. Chesebro, along with counsel, did give a proffer to the state. And I believe there is an understanding that any outstanding emails, text message, or any of those things.
Okay, that's important. We have to explain that. He just said, or the lady just reported to the court, that he has made a proffer to the state. What this means is it's essentially a sealed statement, something generally in writing and or recorded. Basically, he had to say something to the DA that was exciting in their eyes. In other words, to kind of cut through it all, I'm willing to bet he probably said something against former President Donald Trump that was pleasing to the ears of sweet Fannie Willis, the district attorney there in Fulton County. We won't know what that is until the time of court, or at least until it's disclosed to the other side. But at this point, we don't know exactly what it is, but I can assure you it's something that is going to bolster the case of the prosecution, which of course is the state of Georgia. So let's continue.
Things will be turned over to the state in a timely manner.
Indeed, yes.
Mr. Chesebro, do you understand, as I stated before, if the judge does not follow the recommendation, you can withdraw your guilty plea and go forward with trial?
Yes.
Do you understand that this is a guilty plea, well, for your case, you're
Okay, briefly, the way it works, they go through this process, and let's assume that something does not work out or there's a misunderstanding. He might be sentenced to, say, 5 years in prison, which is not what the state is asking the judge to do. The state is asking the judge to essentially give this individual probation and give him first offender status. If he fails to receive that sentence from the judge, then the defendant can say, hold everything, I don't agree to this deal, let's go ahead and continue with the trial proceedings that we already were in the middle of today. Very important that you understand that.
asking for first offender, so once you have completed first offender, you can honestly say that you have not been convicted of a felony, and I'll go over that with you a little bit more.
Yes, I understand.
And do you understand that this plea may be used to enhance sentencing on any other convictions you may have in any other jurisdictions in the state of Georgia or outside of the state of Georgia and in federal courts?
Yes.
Do you understand that you are being placed on?
So whatever he says during the entire course of these proceedings, anything he said in his proffer can be used against him in the future in federal court and other types of actions that may be brought against him, civil and or criminal. It's a very serious matter, and that's the reason why they're making sure he understands everything.
Probation as part of this plea. As being on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of the probation. Do you understand that? Do you understand that if you violate your probation or any of the special conditions, you will be subject to revocation of the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use firearms as a result of this plea and when you're on probation?
Yes.
Do you understand that if you
Imagine that. If he has some kind of problem with the law, technically it can be a speeding ticket going by the letter of the law. If he has some kind of infraction, technically speaking, they can file a motion for revocation or modification of his sentence, and they can literally incarcerate this man in a cage. Imagine being incarcerated in a cage like an animal, and you don't know what's going to happen day to day. This is a real scary and serious possibility. And then think about this. With all the trouble and all the problems in the world and all the crime in the world today, this individual's not allowed to be around a gun. He cannot be in possession of a gun. So when he's home with his family, with his children, whatever, this individual is not able to defend himself any longer. He cannot possess a gun or any type of weapon, specifically a gun. Otherwise, he faces very serious consequences, as this court reporter has just outlined.
you are not a United States citizen, this guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice your attorney may have given you or anyone may have given you.
Yes, fortunately, I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be for a conviction after trial? For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve as a juror, the right to obtain a passport, the right to receive, possess, or transport firearms, the ability to obtain employment, and your membership of any state or federal bars of which you are a member.
Yes.
Do you understand that by pleading guilty, if you use, receive, possess, transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years?
Yes.
Is my
Now remember this, the count number 15, just by itself, I believe they said it has a potential of a 5-year sentence per guilty plea that he enters on that particular count. In the future, until this matter is completely resolved and he's granted this first offender status and his record is clean, whatever, if he is in possession of a gun, he can literally go back into jail, go to prison for 15 years. A man 62 years old, a 15-year sentence, you might as well call it a life sentence.
understanding you're asking the court to treat you as a first offender. Is that correct?
Correct.
Have you gone over the First Offender Act with your attorneys, Mr. Grubman and Mr. Aurora?
She's going to
Yes, I have.
explain what
Have
this
you ever
is.
pled guilty or nolo to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No.
Has your attorney explained fully to you the First Offender Act?
Yes.
Do you understand that if you violate the terms of your first offender or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge in this indictment for which you are pleading?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
I do.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you by the state, the right to testify or remain silent and not incriminate yourself? Do you understand that?
I do.
Do you understand that this guilty plea, you are giving up all of those rights, the right to a trial by jury, the right to remain silent and not to incriminate yourself, the right to confront witnesses, the right of assistance of counsel hired by you or appointed by the court if you could not afford one, the right of the presumption of innocence, the right to testify on your own behalf?
She's going over this. It sounds rather boring, but she's going everything line by line. They want to make sure they literally have him nailed to the cross, so to speak, so that there is no room for any kind of miscommunication, misunderstanding. They're trying to close any and all avenues he may have for an appeal at a later date.
Or to present evidence on your behalf, the right to subpoena witnesses and compel the production of evidence, and the right to have charges against you being proven beyond a reasonable doubt, and the right to appeal if you were convicted after trial. Do you understand that you're giving up each and every one of these rights by pleading guilty here today?
Yes, I understand all that.
Has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No.
It is your decision to waive these rights to enter into this guilty plea because you are in fact guilty.
Yes.
How do you plead to count 15?
I wanted to touch base on that real quick. She just asked him, are you taking this plea because you are indeed guilty? This is very difficult. I've seen this happen many times. You actually have to tell the court, I am indeed guilty of these charges. What is very difficult about that is he probably feels, as he stated on many different occasions, that he's not guilty, that he did nothing wrong. I'm sure he would like to say the truth as he sees it and as I see it. And the truth would be something like this: Your Honor, I'm here because they're trying to get Donald Trump. They want to prevent him from taking office as the next president of the United States. Yes, this case is about election interference, but it's not about the Republicans engaging in election interference. This case is solely about the Democrats, the Democratic machinery mobilizing itself all over the United States in a federal and state level to do anything and everything they can, as the great Alan Dershowitz would say, to get Trump. And that's exactly what they're trying to do. He would love to say exactly what I just said, but if he said it, the judge would say, sir, I cannot accept your plea if you're telling me you're not guilty, but you're going to say you're guilty because you don't want to take a chance of going to prison for the rest of your life at 62 years old. That's what's going on here, and that is what he would like to say. But unfortunately, the way our justice system works, he basically has to lie. He has to say, yeah, Judge, I am guilty. And he probably doesn't feel that way. But if he doesn't say those words, he will probably end up in prison for many, many years, if not the rest of his life, because he is a pawn in all this. The person they want is President Donald Trump. But why Donald Trump is running for office and out doing his thing and hammering away at the Democrats and fighting for you and me, this poor sap's going to be sitting in jail indefinitely if he does not do exactly what he's doing. It's scary, and I know what you're thinking. Oh, if it was me and I was in that situation, I would never take a plea deal if I was actually innocent. Trust me on this. I have seen this time and time again. When it's your butt up there in front of a judge, in front of a jury, and you're going through the process that they started going through Friday morning, you're going to sing a different tune. Are you going to take a chance on risking it in front of a jury, in front of a judge, and spend the rest of your life in jail? Or are you going to try to have some kind of control as to which way this ends up? I can assure you, you're going to do what this gentleman just did, whether or not you're guilty. At any rate, I'll get off my soapbox and we'll get back into it here.
Conspiracy to commit filing false documents in indictment number 23SC188947.
Guilty.
Have you and your attorney signed that indictment?
Yes.
Your Honor, the indictment has been signed and the guilty plea has been. Is your guilty plea freely and voluntary given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea?
Yes.
And do you understand that you would have 4 years from today's date in order to file a habeas corpus petition challenging the voluntariness of this plea?
I do.
And Your Honor, the state has, in fact, checked and confirmed that Mr. Chesebro does not have any felony convictions at all, so he has no criminal history to the state's knowledge. If this case were to go to trial, the state would have shown the following. Between November 18th of 2020 and January 6th of 2021, the defendant and co-conspirators, Donald John Trump, Rudolph William Lewis Giuliani, John Charles Eastman, Ray Stalling Smith III, Robert David Cheeley, Michael Roman, and others entered into a criminal conspiracy to cause certain other co-conspirators, including David James Schaefer, Sean Micah Thrasher Steele, and Kathleen Austin Latham, to falsely hold themselves out as the duly elected and qualified electors for the president and vice president from Georgia following the November 3rd, 2020 presidential election. The objectives of the criminal conspiracy included the following. 1, to recruit certain individuals to falsely hold themselves out as the duly elected and qualified presidential electors from Georgia. 2, to create false electoral college documents, including a false certificate of vote purporting to have been made by the authority of the duly elected and qualified presidential electors from Georgia. 3, to falsely state that co-conspirator Donald John Trump had won all of Georgia's electoral college votes. And 4, to deliver those false documents to the Georgia Secretary of State, the Chief Judge of the Northern District of Georgia, the Archivist of the United States, and the President of the United States citizen being the Vice President. The purpose of creating these and delivering these false documents were to disrupt and delay the joint session of Congress on January the 6th, 2021. By using the false documents from Georgia and other states in an attempt to cause Vice President Michael Pence to violate the Electoral College Act and the United States Constitution. This was part of a multi-state criminal conspiracy to unlawfully overturn the results of the November 3rd, 2020 presidential election in favor of the co-conspirator Donald John Trump, who did not win that election. Specifically pertaining to count 15 of the indictment, federal laws require the Electoral College documents are maintained in multiple places, including the United States District Court, and where the electors met and cast votes. In the Northern District of Georgia, Electoral College documents are maintained in the clerk's office, administrative staff, with other non-case related documents, including standing orders and orders from the 11th Circuit Court of Appeals. Documents maintained in the administrative safe are public records that can be inspected by members of the public, and members of the public can request certified copies of those documents that contain the clerk's official seal. Overt acts committed to effect this object of the conspiracy included, but are not limited to, the following. 1, the defendant created and distributed false electoral college documents to individuals in Georgia and other states in coordination with Donald John Trump for President, Inc., also known as the Trump Campaign. The defendant provided detailed instructions to co-conspirators in Georgia and other states for creating and distributing these false documents. 3, co-conspirator Donald John Trump and John Charles Eastman solicited the director of the Republican National Committee to assist in recruiting persons to serve as fake electors in Georgia as well as in other states. Co-conspirators Rudolph William Louis Giuliani solicited persons to serve as false electors and provided strategic instructions to several co-conspirators concerning the execution of the conspiracy in multiple states. 5, co-conspirator David James Schaefer, Sean Micah Thrasher Steele, and Kathleen Austin Latham and others met at the Georgia State Capitol in Fulton County, Georgia on December the 14th, 2020, created false electoral college documents that falsely stated that the co-conspirator Donald John Trump had received all of Georgia's electoral college votes and delivered those false electoral college documents to Congress and other governmental entities. The co-conspirators also attempted to deliver a copy of the false electoral college documents to the Northern District of Georgia for the purposes of filing, entering, and recording those documents in that court, having reason to know that those documents contain materially false statements that the co-conspirators were the duly elected and qualified presidential electors of the state of Georgia. The defendant was personally present on the grounds of the United States Capitol during the disruption and delay of the joint session of Congress on January the 6th. That would be the factual basis for this plea, Your Honor.
Anything else to add, Ms. Young?
Nothing further from the state.
Is there any recommendation from the state on a behavioral incentive date, which I believe would have to be imposed in this sentence?
The state has no issue with that, Your Honor. We understand that it will be as such.
But what term would you recommend?
3 years.
All right. Mr. Grubman, are you in agreement with that?
Yes, Your Honor, just to clarify for the record that given good behavior and following the rules and the statute, that Mr. Chesebro's probation would terminate after 3 years.
And are you requesting immediate sealing, Mr. Grubman?
Yes, sir.
All right. Is there anything else that you'd like to add onto the record, Mr. Grubman?
I would just like to thank the court, Your Honor. I know this has been a strain on court resources and a strain probably on your patience. And I know from time to time I may have been one of the people that caused that, but thank you for your.
What an odd statement from a lawyer. I don't understand this. I would not be so cordial and exchange pleasantries like this. This is garbage. What's going on with this lawyer? No wonder why this guy's taking this plea deal. This lawyer appears to me not to be what I call a gladiator. Like a lot of lawyers, like a lot of most lawyers, I would say, are what this guy is. This guy's what I call a settler. He's not a gladiator. Thank you, Your Honor, for your time. I know I've been a pain. Are you kidding me, Your Honor? This is a political prosecution. This is unbelievably unprecedented. We say that word all the time, unprecedented, but this is unprecedented. It's a travesty of justice. It's a miscarriage of justice. This is insane. I would be mad. I would not be, man, this guy, whatever. Let's get back into it.
Your patience, and I really do appreciate it because I think the court's done a great job, and
Oh, my God.
we appreciate it on behalf of Mr. Chesebro.
Well, Mr. Grubman, there's
All right, but what's he going to do? Walk up there and give the judge a kiss?
no need to thank me. We are here to give everyone their day in court. So I hope that's what we've been able to accomplish here today. Mr. Chesebro, I have a few questions for you, sir. Do you understand the remaining charge against you?
I do.
And you've heard the rights that you would give up by going forward with this plea. Do you still wish to waive those rights and proceed?
Yes.
And are you pleading guilty today because you agree that there is a factual basis that supports this remaining charge?
Yes, this charge.
Mr. Grubman, are you satisfied your client is competent in understanding that the plea is voluntary and that there is a sufficient factual basis?
Yes, Your Honor. And there is one thing that I was looking over to my colleagues.
If you notice, the defendant there, Mr. Chesebro, said when he was asked by the judge, is there sufficient grounds or words to that effect to support this charge? He clearly stated, yes, this charge. See, this is what happens a lot of times in our court system, is when they want you, they can really, really get you. And the way that they do that is they throw everything at you that they possibly can to see what sticks. And in this gentleman's case, probably what they're going to be able to prove beyond a reasonable doubt is maybe he did handle or mishandle a record on some level, some way, somehow. I really don't know the exact amount of evidence or what the facts are pertaining to specifically count number 15. However, this individual apparently has looked it over and has decided that maybe they do have evidence on this charge, and that's why he's very specific about saying on this particular charge. But remember, when the state, when the feds, when they want you, each and every one of us, they can get us. If you don't believe so, read a book. I think it's called 3 Felonies a Day. There's not any of us, none of us, that if the government could come unfettered into our lives, watch each and every one of us, they would be able to find something felonious about each and every one of us. It's just the way it is, because there are so many rules, so many laws. The government does not even know the exact numbers of laws that we have. But I digress. Let's get back into the conclusion here.
We have an agreement. I believe that the state will agree this does not constitute a crime of moral turpitude.
That is correct, Your Honor. Do you want me to pose?
Okay, this is very important on this particular thing here, on this moral turpitude. You heard him just say it. We would agree that this does not involve a crime of moral turpitude. Have you heard that term before? Well, let me explain it to you because it's a very important concept in our country. Most people in the United States may not be aware of this term or never have heard of this term, but you definitely need to know it because it can affect your life one way or the other in the future. You may or may not be aware of the following, but I believe right now the statistics are 1 in 3 Americans have some kind of arrest record. And they believe it's even going to be higher than that in the future with felonies. I mean, that's just an unbelievable statistic that you're going to have half of us with a felony conviction and the other half of us watching people. It's just so easy to get something like this. At any rate, let's talk about moral turpitude, as defined on Wikipedia, is the legal concept in the United States that refers to an act or behavior that gravely violates the sentiment or accepted standards of the community. Well, that's one of those loosey-goosey laws, loosey-goosey definitions that basically is subject to interpretation, which makes it extremely scary. But why is this gentleman going out of his way to make sure that the judge understands and that it's recorded properly in the record that all sides agree that this particular instance, it is not a crime of moral turpitude, period. And the reason for that is as follows. This individual, I believe he said he was a graduate of Harvard Law School. So he spent years and years, went to school, did what he had to do for school, and he can end up losing it because of moral turpitude. If you are considered a person that is basically just a bad person, any type of moral crime can cause you to lose your law license. If you're a tradesman, it can cause you to lose your plumbing license, electrical, HVAC, and especially for attorneys. Their reputation is their license. If you don't have a good reputation as a lawyer, you're not going to be a lawyer for long because the state bar of your particular state that regulates the attorneys in your state will simply just pull your law license. It's just that simple. So at any rate, let's get back into it and let's hear the conclusion of this particular thing.
That is correct, Your Honor.
Okay, so both sides agree to
Mr.
it.
Chesebro,
Have that
It's not moral turpitude.
in the sentencing sheet. That would be great. Thank you.
understood, and I hear that that is without objection from the state, and so consistent with the other resolutions in this case. We'll include that on any final disposition form. Mr. Chesebro, do you have any kind of a weapons carry license in the state of Georgia or elsewhere?
No.
All right. Well, I agree and find that there's a sufficient factual basis for the charges as proffered by the state, and I find that this plea of guilty is knowingly, voluntarily, and intelligently entered. Mr. Chesebro has asked to be sentenced under the First Offender Act without objection from the state, and I'll approve that request, withhold adjudication. But I must notify you, sir, that the plea can't be withdrawn simply because you don't abide by the terms of the sentence. And the terms of that sentence would be as recommended by the parties on the sole count 15. The sentence would be 5 years probation. There would be payment of $5,000 of restitution to...
State of Georgia.
All right.
There are state's officers.
All right, and that will be later clarified through probation and reflected in the final disposition form.
And Your Honor, we will provide that information to probation, exactly who that payment needs to go to.
Understood, and as we've done before, the specific language of these special conditions is agreed to by the council. If you could email us to those, we'll make sure they're reflected appropriately.
And Your Honor, sorry to interrupt,
Sure.
but Mr. Chesebro does live in Puerto Rico, so to the extent we could recommend to the probation office that his probation be transferred there, that would obviously be
That might complicate things. We do have our representative from probation here today, Ms. Pretty, who is usually able to enlighten us on these kind of complications. Ms. Pretty, any thoughts?
Once you're on probation and you've been convicted or you accept a guilty plea, you have to serve probation. If that's what the judge says you have to serve. Well, each state has their own probation department. And if you're not living in the state, or in this case, the state of Georgia, the state has to agree that they will allow another state to take over as far as monitoring your probation sentence. If the state of Georgia, for example, says no, we're not going to allow it to be transferred, well, you're in big trouble, because you're not going to be able to leave the state of Georgia. You're going to have to make Georgia your home until such time as you have served your probation. Also, if the state, or this case, the territory of Puerto Rico, says, hey, we're not willing to accept this individual, well, you got another problem then. You cannot move or go to Puerto Rico. It's very, very intrusive on your life once you're on probation. You have security problems. You cannot protect yourself because you cannot own a gun. Your ability to move is definitely restricted, and severely restricted in most cases. It's a very serious and restrictive, life-altering situation, and this gentleman here is not going to be having a good time. He is a lawyer. He has always been on the other side of this equation, and for the first time, he's going to be on the other side, and I think it's going to be rather eye-opening for him, and it's not going to be fun.
When we have someone who's in one of the U.S. territories under supervision?
That I would have to contact the supervisor about him being in Puerto Rico and how that transfer would happen. Normally in other states, we would just do paperwork for the ICOTS, and he would contact the officer, but this is in another area. So if you give me 5-10 minutes.
All right, my friends, we're going to stop it at this point. You have already heard the meat of what was covered on this particular video that I was reviewing. I think the takeaway here is that right now they are doing everything to get Trump that they possibly can. This particular AG, this particular district attorney, is focused on taking Trump out. They, along with the Democrats, her office on a state and federal level, is wanting to commit election interference. But the election interference is not from Donald Trump. It's from the district attorney's office right there in Fulton County, Georgia. Of course, this is my opinion. This opinion is shared with many Americans across the world, for that matter. It is embarrassing. It is outrageous. If this happened in El Salvador or some other country, we would have the legacy media and the talking heads everywhere shouting from the mountaintops how outrageous it is that these countries are taking out their political leaders, their candidates, by using means such as what's going on right now in our country. It's sad. It's wrong. It should be stopped, because once this is out of Pandora's box, today it's the Republicans that are suffering. I can assure this, since that door has already been opened, it's just a matter of time before things line up to where the Republicans can get retribution on some Democratic family or some Democratic candidate. It's just a matter of time, and it's a very sad series of events. A couple things that this particular defendant Mr. Kenneth Chesebro needs to be concerned with, in my opinion. He may have taken care of his criminal liability as far as the state of Georgia is concerned at this particular point. However, the feds can always jump in and file charges on him if they chose to. What happened here in Georgia on the state level by no means ties the hands of the feds on the federal level, aka the Department of Justice. Now, I will say that it is the policy of the Department of Justice not to go after a defendant such as this defendant that has taken care of his charges on the state level. But as we all know, this particular case is anything but normal. These individuals have violated everything that was special about our justice system. They have thrown out discretion. They have thrown out all kinds of discretion that they normally are entrusted with by the people. And that is one of the really sad things that's going on right now. I promised you at the beginning of this video that I would tell you why this particular case, this particular guilty plea, does not affect Donald Trump. And here is the reason why. Time. That's right, time. What do I mean by time? Well, the reason that this individual, Kenneth, is before the Fulton County judge right now is he refused to waive his right to what's called a speedy trial. So that tied the hands of the DA, and they had to go ahead and give him a trial. I believe it's within 90 days, within 4 months, whatever it is, it has to happen quickly. If you remember, the attorney general, the district attorney, went to this particular judge and said, hey, even though this is a RICO action involving all these particular people, we still want you to go ahead and allow me to try all the people, including the president, right now. And gratefully, the judge said, no, there's no way that I'm going to allow that to go forward. However, two defendants, and this person's one of them, said, no, I'll go ahead and take my chances now. As a matter of fact, Friday morning, they were picking a jury for this guy. He just second-guessed himself, had a second thought about it, and decided he would go ahead and take a plea deal. So the reason this is not going to affect President Donald Trump is because of time. The election is essentially now. We vote next November. There is no way that a RICO case involving all these type of defendants is going to make it through the process this fast. I don't see it happening. There's just no way. Generally, a RICO case of this type of caliber would take at least 4 to 6 years. There are millions of documents. There is a ton of evidence to go through. And there are many lawyers that are involved. Each defendant has their own lawyers. And these people all have to basically keep in touch with the prosecution and perhaps with each other on certain things. So it's a very, very large expenditure of resources. We simply don't know what's going to happen in the future, but I can guarantee you one thing. There's no way this Georgia case makes it to trial before the election, and we can all thank God for that. Folks, as always, I truly appreciate you joining me today. It humbles me, and I'm blessed by you joining me to hear what I have to say. Keep that free mind. Never give up, and until next time, I am J.R. Dukes.